I call Melissa Lee.
Thank you, Mr. Speaker. Before I'd like to thank the Minister for bringing this bill to the House and commend the member who just sat down. He speaks sense. And it's a great opportunity to speak in support on the first reading of the patents, Trans-Tasman patent attorneys and other matters amendment bill. So before I actually go on, I'd like to wish you, sir, a Happy New Year. And especially since yesterday was the Lunar New Year for the Chinese and Koreans and many, many nations that actually celebrate the Lunar New Year, I'd like to say, Kung Hee Fat Choi, Xin Nian Kuai Le, Sehe Pok Mani Badaseo, which actually means may you receive lots of blessing and luck for the new year. It's the year of the fire monkey, and for some they said it is the year of the fire monkey. And monkeys are aged, they're born this year, or 12, 24, 36, or 48, or 60. So they do actually say for those who are actually born in the year of the monkey, especially in the fire monkey year, they should avoid the color red. Apparently so. Anyway, that was a little bit of trivia there for you, sir. The bill, as it has been put to this House, is fairly straightforward and to deal with matters arising from the current application of the Patents Act of 2013. The bill will also align, as other members have actually said, patent system more closely with that of Australia's and better reflect our closer economic relations through integrating Trans-Tasman regulations. When passed, this amendment bill will be the first major update to the way our patent law profession has operated in over 60 years, sir. In doing so, we'll strengthen our reputation as a good place to do business and reduce costs for applicants. And I think the previous speaker, Honourable Clayton Cosgrove, actually talked about the reduction in costs. And instinctively, you would think so when you're only making one application that is actually going to both countries instead of having to do both, one in New Zealand and one in Australia. So instinctively, you would think that the cost will be less for those businesses who are wanting to register their patents. It is important to remember that New Zealand patents are the intellectual rights that are granted for an invention to an individual or a company or group that has created a new product or process. Patents cover a variety of areas and can include new products, processes or ideas. And I'm sure that, we have seen court cases dealing with both iPhones and Samsung, right? Apple and Samsung, who have actually, intellectual properties. They were trying to protect their inventions. And I know that New Zealand inventors and New Zealand writers also protect their work and creative output through copyright, as well as their inventions through patents, sir. And I think protecting our creations is very, very important. And this bill will make three main changes to the 2013 Act. It amends the grounds on which a person can oppose the grant of a patent under the Patents Act of 2013 and proposes a single patent application process and a joint registration, as I've just explained, that you don't have to do it both in New Zealand or in Australia. You can just do one and it goes to both Australia and New Zealand. To explain that this bill means the first change proposed in the Act will be amended to explicitly exclude lack of unity of invention as a ground of opposition during the pre-grant process. And what it actually means in terms of unity of invention is a term used whereby a patent application can be applied only to one invention or a series of close or interrelated inventions, sir. Under the current wording, there is the potential interpretation for unity of invention to be used as grounds to object to a patent application. The 2013 Act introduced this grounds of opposition into the pre-grant process by allowing a grant of a patent to be opposed on the grounds that an accepted patent application claims patent protection for more than one invention. a wording that was unintended when the 2013 Act was actually legislated. I know it's a little bit confusing. The second and third changes introduced by this legislation deals with consolidating and better applying existing laws between our two nations, sir. The Single Economic Market Program will support a single patent application that will establish a single application portal where applicants could file one set of documents and pay one fee. And as I said earlier, that basically means that we will reduce the costs, in my view. I look forward to the submission process in the Select Committee, sir. I believe this is a good bill, and I commend it to the House.
I call clear